Okay. Anybody have a transactional issue they're working on that is needs addressing this morning?
I
Yeah.
wish.
I do.
Okay, Yvonne?
Yeah, it's an interesting one with mobile homes again, because I keep falling into those. I had a situation getting through almost the whole escrow period and the buyers being denied. What I've done in the past, besides what the park puts out regarding what people have to do, I've talked to the buyer's agent and given them additional kind of, we really need to know that your buyers can satisfy in this, and this way. This particular park does have pretty stringent requirements. So this deal that we were in escrow for that just canceled, I trusted that the buyer's agent really was aware of their buyer's financial situation, and it turned out it was complicated and took a long time, and the park finally said they aren't going to be approved. So my question is, how far can we as listing agents go in pressing the buyer's agent to provide us with qualifications for their residency, not for the purchase? Because the residency is between the buyers and the park, but it affects all of us. And I've had this happen in the past. I had one escrow 2 or 3 years ago that we lost 3 buyers for lack of approval before we got one in place. So
I usually make it, we won't accept an offer unless the buyer in the mobile home park has been pre-approved by the park, because that's one of your big things.
it is, but this park will not they will not start the application process until they're in contract.
Oh, what a shame.
Yeah, this park is a little difficult. It really is. And because of that, then I've just started kind of setting up my own requirements and talking to the agent for the buyers, etc. But my question is, how far can we go in pressing a buyer's agent and therefore their buyers to provide us with the information needed to satisfy the park? Because it's not our arrangement.
Right. And you're using the royal we, which I always discourage.
Sorry, the seller.
The seller, how far
The
can the
seller.
seller go?
Right. How far can the seller go?
Yeah, yeah.
Exactly.
How far can we recommend the seller go?
Yeah.
But not we.
Got
Okay,
it.
that's it. I think you have a serious conversation with the seller, and then do you have an outline of the park's financial requirements?
The only thing that they will provide ahead of time is it's called the summary of qualifications, and it gives kind of the basic information, but it's not nearly complete enough. So I ended up writing up my own thing to provide to buyer's agents, saying, if there is any question as to whether there will be residency approval in this case or not, can you provide blah, 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 blah.
Okay. Yeah.
But again, it seems like a fine line of not stepping over.
Yeah. Well, why don't you do this? Send me what you wrote up.
Okay.
As an outline, and I'll run it by legal counsel and see if it's something we can recommend the seller include in their package before they accept an offer from a buyer.
Okay. All right. That's a good idea. Thank you.
Yeah,
Okay.
because the other thing I'm thinking too is you can give them a time frame that all the documents need to be to the management, and they need to be approved or disapproved within X amount of days, not to hang yourself up that way.
I'm not quite sure how that would work. I mean, the requirements for park approval, I think, and this is for the state, I think through HCD, that they have 15 business days to respond to the buyer. But you're talking about something that then the seller would be requiring.
Yeah, as a counteroffer, saying that, you have approval or disapproval, if you're saying 15 days, within 15 days.
Mm-hmm. Okay.
Yeah, well, the park has to respond within 15 days. So if you're, you say that all the buyer's application has to be submitted within 5 days.
Right, yeah, and that's in the contract, yeah,
Okay.
but,
That's what I thought.
And it's 15 working days.
right, which gives them more. The other thing that's has come up is that if as their information, buyer's information is going through the process with the park, if the park comes back and says, we need more information, we can't make a decision, then the park says they have the right to start the count of 15 days again from that point,
Wow.
which seems a little funky to say the least.
Okay. Well, let's
anyway.
do the step we talked about and send me the
Okay.
form.
Thank you.
I'll
I
run
will
it-
do so.
Yeah, I'll run it by legal.
Okay, thanks much.
Okay. Anything else anybody's working on that needs addressing? Okay, I'm going to start here with, let's see, I don't know if you can see this.
Oh, it's Ashley's birthday today.
Yeah, did that show up? That little,
Yeah.
the little
The
birthday.
llama did.
Yeah, the llama. Okay, well, I don't know why the llama's so small. But anyway, yeah, apparently, I thought it was yesterday, but apparently today is Ashley's birthday, Haley's birthday.
Oh, it's Haley's. I saw
Haley.
something on Facebook, gave me a notification.
Yeah, so if you have a chance, send drop Haley a birthday note. I'm going to start with the TOPA. We had, why is that doing that? That one, here we are. Can you see the disclosure regarding real estate agency now?
Yeah.
Okay. So in the RPA, in the grid, there's an area about occupancy, possession. And M3 here, so it's occupied units by tenants or anyone other than seller. And if it's occupied by tenants, you check the box, tenant occupied property. And it will attach the TOPA form to your package. I'm not sure it's attached to this one. Let me check. Doesn't look like it is. So I'm going to go in separately and pull up the TOPA. Can you see the TOPA now?
Yep.
Okay. Okay. So the TOPA form, as always, there's a preamble here about who's what and where. And then there's lots of choices. There's 1A, tenants to remain in possession. And then under the terms specified in paragraph 2. Or B, property to be delivered vacant. And then there's this proviso about if you've checked that the property is to be delivered vacant. And then there's a B2, if the seller tries to get the tenant to leave and they don't depart within 5 days prior to close of escrow, the buyer may cancel this agreement, or they may buy the property proceeding with the tenant in possession and waive any damages or claims against the seller. So that's kind of putting the buyer on notice that, the seller will use best efforts, but there's no guarantees. Okay. Okay, yeah. And so if the seller has a seller possession after close of escrow, no tenant shall remain by the time specified except, and then they would put in the parties. There's if you are buying subject to the tenant remaining in possession, then you have to deal with paragraph 2. And I'm not going to do paragraph 2 today because you can see there's lots of options in paragraph 2. including estoppels and all kinds of things. But what we had was we had a buyer. We have a listing with a tenant in it, and the tenant has been very difficult. They've been kind of difficult to arrange for showings of the property. It's a, I think it's a $2 million property or something. They've said they would, allow it to be showed, and then they change their mind and say, oh, no, that date's not convenient. And the seller had an agreement with them that they reduced the rent for the tenant's cooperation in showing the property, but the tenant still wasn't cooperating, even though they took advantage of the reduced rent. So our agent, the listing is actually about to expire. I think it was a 6-month listing because, they had made it so difficult to show the property and everything. And finally, we came up with a buyer, and the listing agent actually was a client of, the buyer is a client of the listing agent as well. So we have dual agency, single agent, dual agency, that most difficult thing, but we're dealing with it. And because the tenant has been difficult, the agent set the closing after 60 days past the contingency period, so that after contingencies are removed, the seller can give notice to the tenant, and they should be vacated by the time of closing. So that's the mechanics of that. So that's kind of why we check the box, property be delivered vacant. Now, this form here, rent cap and just cause addendum, is attached to the TOPA. So when you're dealing with a tenant occupied property, whether they're going to be vacated or whether they're going to stay on, you've got to deal with this form here, the RCJC. And this form is an addendum, and it talks about California law. And if your property is not exempt, then you've got a whole bunch of hoops that the landlord has to go through as in consideration of rents and evictions. Now, the exemptions, the primary exemption we're looking for here is 2.3, single-family residential property that is alienable separate from the title to any other dwelling unit if the notice below is checked and delivered to the tenant. So here you got a single family residential property that can be delivered without any other property having to be conveyed at the same time. So, a duplex wouldn't work, or a property that has a separate parcel that's going to be conveyed with it that has a separate, residence on it or something. But in most cases, we're going to have a single family resident property that's going to be delivered individually. And so we can check this exemption box. And then there's nothing else we have to do with this form. And all this legalese in here, it all applies. It says, it's saying that the seller is exempt and they don't have to comply with any of these.
What about an ADU on a property? Would that mess it up?
No, an ADU, well, let's see. A single family residential property. So a single family residential property with an ADU isn't a single family residential property. It's a single family residential property with an ADU.
Right. So it wouldn't be exempt.
It would be, it would mess it up. Yes.
Yeah. Okay. All right.
It wouldn't be exempt. So, and then this form gets signed by the tenant and the landlord. Now, in this case, we never saw the lease between the seller and the tenant. And this preamble up here refers to the rental agreement, dated such and such, in which so-and-so is the tenant and so-and-so is the landlord. So we could fill in the property address and we could fill in the tenant's name and the landlord's name, but we didn't know the date. So we sent this all over to the seller and say, fill in the date of your lease and then sign it and send it over to. So that was something we don't deal with every day with tenant occupied properties. Any questions on that? Okay, then I'm gonna go on to let's see. I'm gonna go on to probate listing addendum that came up. And again, this isn't, we don't deal with probates very often, but once in a while, some of our agents actually farm attorneys who deal with probates in order to get listings. One of our agents actually worked for a probate attorney before becoming a real estate agent. She's very knowledgeable in this area. But this is a probate listing addendum and advisory that gets attached to the regular RLA as an addendum. And the question came up, there's questions here that need to be answered. The property is part of the probate estate, conservatorship, guardianship, receivership, and there's a limited number of things here. The question came up around this number 8, which is notwithstanding any term of the listing to the contrary, seller warrants that the title of the property is as follows. So what you're getting at here is who the current title is listed in. And sometimes, the title hasn't been changed yet. So it's listed in the deceased's name. And that's what you would put here. Say it was the name, whoever's on title at the time you're doing the listing. So it may be different than the name of the trust or the probate that's selling the property because the title actually hasn't transferred to that entity yet. So that was the answer here, that we put in the name of the current, whoever is currently on title. Okay, that doesn't come up very often, but it does. Next, we Parmita's on the call here, and Parmita sent us, and we always take into consideration any suggestions, like Yvonne suggested this morning about this mobile home qualification list or whatever you're calling it. Parmita works in Petaluma. And the city of Petaluma provided these forms, which are quite helpful, actually. So it says smoke detector locations, and it suggests in the home where smoke detectors would be placed. And this is for a corridor hallway, this is for a split hallway, this is for a separated living, sleeping area. So these are different configurations of floor plans and show where the city of Petaluma would like to see smoke detectors installed. Or actually, maybe they require them to be installed there. Then it talks about carbon monoxide alarms, where they were required in the existing dwellings and so forth and so on. And then they have the water heating bracing diagram. And it talks about how that can be done and so forth and so on. So these are 3 useful little documents. And Parmita's question is, would we want to include these with our sellers, give them to our sellers sellers and to the buyers at the time of at the time of a listing or at the time of a sale. And we looked into it further. There, obviously, the NHD forms generally have links to the earthquake hazards form, which covers the smoke detectors and water heaters. But they don't have diagrams like this. There is a diagram buried somewhere in one of the documents about the water heater stuff. But it's not as convenient as like just having these three diagrams. So, we feel we're covered in terms of making the disclosures, but Parmita's concern, and it's a good one, is that, well, maybe the buyer doesn't dig through, read all the way through all that stuff and doesn't have that stuff handy in front of them like they would if they just had 3 pages here. So I'm going to send these on to our legal too, because this is a city-specific thing for Petaluma. There, we did a little research, and so far have not found a statewide diagram that would apply to all municipalities throughout the state. It seems to be a city-by-city election kind of thing. But we'll send this on to legal also and see if it's something we can either adapt or we can just send it along in our packages as an example for parties and suggest that they consult with the local municipality or county to see that these documents are accurate as to the property they're purchasing or selling.
I think that would be helpful for sellers because sometimes they don't know they have to be inside the bedrooms and in the hall, and you tell them and they go, well, that's crazy. But if they had a form showing it, would make that little discussion much quicker. Yeah,
great. Well, we're going to work on that, and that may end up in our TC lists of documents we provide to sellers and to buyers. Does that make you happy, Parmita? Okay. Parmita's not listening. Eric, you have a question?
Yeah, it's been a while, but the last time I checked with the carbon monoxide detector, it didn't say in the packaging if you wanted to go high or if you wanted to go low. And I know that there's carbon monoxide detectors you can put on the ceiling, and there's also the plugins that you can put on down low. Is there a preferred location for carbon monoxide? Because it should either be a heavy gas or a light gas, but I haven't found any definitive information.
Let me see what this one says. Shall be provided with cover in accordance with carbon production levels shall be acquired in a specific dwelling unit and the permits obtained to. So this is referring to sections of some ordinance here. It's outside of each separate dwelling unit in the immediate vicinity of bedrooms on every level of the dwelling unit, including basements. Multi-purpose alarms. This particular form doesn't address that, and I have no personal or professional experience related to it, so I can't give you an answer.
Noted.
Okay. I think you read the manufacturer's spec on the package, the carbon monoxide device, and that might give you guidance about where it's best located.
Yeah, in the past they've been totally vague as to where.
Okay. If I can come across an answer, we'll readdress that at another time. Okay. Anybody, unless anyone else has a experience with that. Yeah, Mari.
Yeah, I wonder about that because I wonder what kind of if we do make a statement and something happens, like a house burns or whatever, what kind of liability might we have? So I feel like, I mean, I've never really thought about this before, just followed the what's in the reports and that kind of such, but it seems like it could be a liability if we were handing something out.
That's why we're going to have it reviewed by legal.
Okay.
we don't want to create liability for ourselves, but we, as Patty said, you know, it's a convenience, it's useful
Mhm.
document if it doesn't create legal ramifications for us.
Mhm. Okay.
Okay. The next thing we're going to deal with, and it's related to all this, is let me go back here, and one thing we do provide as required by state law now is this water conserving plumbing form. This is in all our forms now, and there's there's one for exempt sellers as well. The seller needs to give this to a buyer, and it talks about the installation of water conserving plumbing fixtures and what's required under the law. There's exemptions, and just if there are water conserving plumbing fixtures, disclosures about those, and non-compliant water fixtures. Buyers are sellers and buyers are advised to consult with home inspector or contractor to determine if any fixture is non-compliant. Here's a carbon monoxide detectors installed on or before, and it doesn't say where.
No, it doesn't say.
But anyway, this form, compliance with installation required, placement of detectors of properties outside of each. Just depending on the local building standards and manufacturer instructions. Okay. So we don't know what that is. Buyers advised to consult with a professional, or buyers choosing to determine whether the property has carbon monoxide detectors installed as required by law. So it's not up to us. Anyway, this form is a very complete form about those two topics, and it is part of each of our escrows.
But
So-
doesn't that form say that the seller will or will not bring those up to compliance? I thought that there was a clause in there somewhere.
I think that's a separate
Oh, is that a separate form?
form, yeah, where there's an election for the buyer and or the seller to do those things.
Okay.
But no, that relates to the fire stuff. Remember that the buyer, the seller and buyer agree that either the buyer or the seller are going to do mandatory things that are required related to fire hardening.
Yeah, there's something about the plumbing fixtures too, but I would have to look.
Yeah.
There's Novato, the city of Novato requires, they have a form, and the seller has to state how many fixtures they have of what type, and are they in compliance or not, and if they're not, then they're supposed to be brought up. But that's a city
Mhm.
again, yeah.
Okay.
Hmm.
Okay, Eric.
I thought I had the impression from that form that you're looking at that someone is responsible for the upgrading of non-compliant water fixtures to compliant. And it seemed like it was the seller's responsibility. Otherwise, what's the purpose of the form if it's not saying someone needs to do it?
Because we got to read these forms, right?
I
It
think I did once
says
upon a time.
that all single-family homes built on or after 1994 will be equipped with water conserving fixtures. Okay. And then it talks about commercial properties. or improved plumbing fixture, final approval of the alteration or improvement increases floor area space by more than 10% or has a greater cost than $250,000 for any in the room, which requires a building permit. So this isn't triggered until you go in and do an improvement that increases the floor space 10% or a cost greater than $150,000. So these there's a 1-year exemption for buildings started for demolition. Okay. So that seems to be the trigger, Eric, is that the commercial building that is altered or improved. I'm not sure that's not just talking about the multifamily.
Yeah, there used to be a form, maybe it's not there anymore, where you said if the seller was going to do it or not.
Well, let's go back and look for that. Water.
Yeah, well, maybe that form isn't there anymore or whatever.
Let's see. There's a statement of compliance here, so let's look at that one.
Oh,
But that's water heater.
Oh, is that what was that water here?
Yeah, that was water heater. Maybe that, there used to be 2 forms about plumbing fixtures, but it doesn't seem like there is anymore.
Okay. I'll do a little more work on this, and I'll have it for you next week.
Yeah, that'd be good.
So it's a good question, whether it seems that this alteration paragraph applies to the multifamily and commercial properties. So it's not clear to me in this form, if the property has non-compliant fixtures, what's going to happen to it. So let me dig into that and get you an answer by next week. Unless anyone has recent experience with that.
I'll look around and see if I've got one of the forms somewhere.
Okay.
If I find it, I'll email it
Curtis,
to you.
Curtis put in the chat, if you look into the chat, there's a link that says EPA, it's like where you should place the carbon monoxide detector. And again, that I'm not going to pull that up necessarily, but we can refer the parties to sources like that, but we never want to tell them, you know,
Right.
that
Yeah,
this is where it should go. Yeah.
I had a home inspector tell me that they should be about 5 foot from the floor. And I forget which inspector that was, because the one that was in the house was way too high. And he had us move it, so
Okay.
who knows?
Well, I don't understand, because a lot of times you can buy the carbon monoxide and smoke detector combo.
Yep.
And I have them all because I run a family childcare too. But when we redid our kitchen, the inspector had to come in, and he was fine with the combos being on the ceiling. So, but my single carbon monoxide I did for daycare licensing, when it was only a single, it wasn't the combo. It had to be like 4 or 5 foot or something like that down to the ground.
Right.
Mhm.
But Humboldt County building inspector was fine with the combo being on the ceiling. So I don't know.
Yeah. Well, it is
Confusing.
subject to the local jurisdiction. Here in the Petaluma form, it says multi-purpose alarms, carbon monoxide alarms combined with smoke alarms shall comply with section R36, and this is the local building code, I take it. All applicable standards and requirements for listing and approval by the Office of the State Fire Marshal for smoke alarms. So it does allow for the combo units. but you, again, you'd have to look at the specific municipality code to see where they want them. Okay. That's kind of all the issues I've got to cover today. I want to remind you the legal update on 5/31, May 31st. And that will be 9:30 to 11:30. It's a general legal update. It's not specific to any one topic. So they're going to cover the broad stuff that's happening, the market conditions and how they're affecting us in legal manner, and any horror stories. They always like to share their horror stories that have crossed their desks recently, and any laws that have changed and stuff. So be sure to sign up for that. I put a link in the mailing I send out. When I send out the recording, I'll add that link as well. But so it does require your pre-registration to get the link to watch the webinar. And as in the past, now they are recording these, and they will be in the archives on the Broker Risk Management website. But we do encourage you to watch them in person, live, because you may trigger a question that you might have, and they can respond to it in real time. So it's a chance for you to actually talk to the attorneys, which we don't have all the time. Okay, so if you haven't registered already, keep an eye out for the link and get registered. Let's see, Curtis added another comment that the combo units he believes are designed to work on the ceiling, but the local fire department told me you should use the lower one because it works better. So, so again, we're going to get different feedback from different municipalities and different inspectors on those things. All righty.
Well, thank you, Gary.
All right.
Thank you, Gary.
Okay, everybody have a good
Thanks
week.
much.
Thank
Okay,
you.
Bye.
Later on.
3-day weekend.
Yeah,
You too. Bye-bye.
bye-bye.